contrary to popular belief, briefs are better when written in advance. And let me be clear, some of what we're going to talk about today is do what I say, not what I do, okay? Because I am a terrible procrastinator. I'm sure other people are as well. But the truth is, if you can get the brief done earlier, the better. And that's something you got to think about. So, for example, think about how much time is it going to take me to put together my appendix or my excerpts of the record. That takes an extraordinary amount of time sometimes. And a lot of times I get to the end of the time that I've spent, I've done the brief and everything like that, I'm about to file it, and all of a sudden I'm rushing around dealing with the appendix and the excerpts of the record. Judge Brand,
so
when you get into a pinch, how easily can you get an extension in the federal courts?
Well, in the district court, they're usually often willing to give you an extension of time. I think partly because bankruptcy appeals are not their favorite thing to do. So if you want more time, they're kind of happy to give it to you so that they can work on things that they like to spend more time working on. In the bankruptcy appellate panel, you can usually get extensions there too. You must request them by motion, and of course we're not going to allow you to abuse it, but I think that the BAP, in my experience, favors hearing things on the merits, so we are open to receipt of motions to extend the time for appeals. The first motions are granted usually by the clerk of the court on behalf of the panel. After that, it's going to go to a motions panel of judges to determine whether whether it should be granted or not. And then, of course, in the Ninth Circuit, generally you can obtain, an automatic almost extension of 30 days, but after that you have to request it by motion. Alana, what happens in the state court?
The state court is a good or bad place for procrastinators, depending on how you look at it. The parties can stipulate to a 60-day extension without the court getting involved at all. Beyond that, you can apply for extensions, and they're generally granted even before the other side would have an opportunity to file an opposition. The other thing in the California courts is that there's an automatic grace period, so add at least 15 days to whatever your deadline is on the docket, because when you miss your filing deadline, the only thing that happens is the clerk eventually sends you a courteous letter noting that you have not filed a brief and inviting you to file it within 15 days. So a very laid-back system.
All right, so the next question to ask is, who's the audience? Who's actually going to be reading your briefs? Judge Brand?
So again, talking about bankruptcy appeals, you have to ask yourself that question, when do you file your notice of appeal? Because at that time you have an option to elect the district court or the bankruptcy appellate panel if you're the appellant. And if you don't elect it then, you've waived the right to go to the district court. So you have to think about it right away. If it's the district court, your audience is going to be at court with more general knowledge of the law and not a specific bankruptcy knowledge. If it's the bankruptcy appellate panel, you get 3 bankruptcy judges whose day job is to decide bankruptcy cases day in, day out, and we do this for fun as our side job for no extra money. But one of the things we say at the beginning is, don't explain to us what the automatic stay is. When you start your oral argument, we know that, so you can dive. You have the advantage of diving right into your argument.
Can I tell a quick war story? So I was in front of a district court judge who will go unnamed. I was there for a fairly complicated petition to remove a particular matter out of a bankruptcy court up to the district court. I'm sitting in the back of the courtroom, and I'm watching a carryover from an earlier hearing where the U.S. attorney had filed charges for bankruptcy crimes. And the judge is talking to the U.S. attorney, and at some point he says to her, so, what you're saying is that this was, what's that phrase you bankruptcy people use? And she says, relief from the automatic stay? He says, yes, that's the one. Okay, so that, not all district court judges are going to struggle with the idea of relief from the automatic stay. Certainly the BAP judges won't, but district court judges, that may be kind of the level of sophistication that the judges have with bankruptcy matters.
Well, and then for the Ninth Circuit, of course, they're generalists, and you have to remember that their bench memos are going to be written by their law clerks who are generally, right, fresh out of law school. What about the state court, Alana?
The state court is like the Ninth Circuit, so you have generalists. The difference would be that the research attorneys doing the work in the state court tend to be career research attorneys, so they are not straight out of law school, and they have probably seen this before, so you're not starting as much at ground zero. But still always a good idea to present everything so that someone who was new to this area of the law could understand it.
So what is the role of the appellate court?
So as someone which told me, and I thought it was particularly apt, is that when I sit as a bankruptcy trial judge, I'm trying to find the right answer. I'm trying to find the truth. I'm trying to find what is correct. When I'm sitting as an appellate court, I'm looking to see if a mistake was made. Did the trial court make either a mistake of law or a mistake of fact? And then, of course, an overarching concern that we often have is, what is the impact of our decision on other and future cases?
I think one other comment on the looking for mistakes is that the Court of Appeal also is looking for mistakes that maybe change the outcome of the proceeding. We like to say no one ever gets a perfect trial. And so sometimes you've got a great mistake and you get very excited and you look, I caught them, they messed this up. But if it wasn't going to change the outcome, the appellate court is going to shrug its shoulders. So it's always good to be looking at what was the impact of the mistake.
All right. One of the other things that you should think about is whether or not going forward with the appeal is going to expose your client to attorney's fees. In the bankruptcy context, this is a really interesting issue. There have been some recent cases. There's a Penrod case out of 2015, a case called Boz out of 2016. We could talk for an entire panel just on those two cases alone. But the point is, even in bankruptcy matters where we used to think that if it was a bankruptcy-specific issue on appeal, then no attorney's fees, prevailing party attorney's fees could be possible. That's not necessarily the case anymore if there's a contractual obligation to pay attorney's fees. You also need to think about what the rules are, and you have to be sure to follow the rules. And the materials that you have that were sent to you by email are more specific than the one that's on the slide. So there's some information on those. But a couple of rules that I want to point out today are that the Federal Rules of Bankruptcy Procedure ask you to include a statement of the issues presented and for each one, a concise statement of the applicable standard of review. If you're like me, you're used to having statement of issues, and then the next section is standard of review. But the rules actually require you, or I don't know if anyone follows it, I'll ask Judge Brand in a moment, the rules actually require you to include those together. What do you think? Are people following that rule?
No. I mean, we usually see the issues as one section. As you stated, in the standard of review as its own section. In that section, they will say the standard of review for this issue is this. The standard, they'll delineate the separate standards of review, but in its own section.
Yeah. A couple of circuit rules that I think are interesting that we usually don't follow is that on one, you're supposed to state for each issue where in the record on appeal the issue was raised below. I've never done that. I've never seen anyone else do that. But technically, that's what the circuit rules require. The other one, which I do follow, is if there's a statute at issue in the appeal, you're supposed to actually attach an appendix with the statute verbatim, or you're supposed to include that in the body of your brief. So next, Alana, how about font size? What can we do to make things easier for the judges to read?
There's been a lot of focus and angst about this recently, particularly in the California Court of Appeal, but also more broadly as judges are reading on tablets, which changes their interaction with what they're looking at. There's a book called Butterick on Typography for anyone who is really interested in a deep dive into this that analyzes margins and font size and font type and what impact that makes. But in general, you want white space on the page to make it easier to read. And you want to not try to cram in as much as you possibly can if you've got a page limit, play with the margins and things like that.